Testing. This is a test of the Southern Circuit Court of Appeals.
Good morning, everyone. We're here today for oral arguments. We are going to begin with case 24-2871, John Doe versus Young, and we'll begin with oral argument. Mr. Brown, from you.
Good morning, judges.
Morning.
May it please the court.
Yes.
My name is Brandon Brown. I represent the plaintiff appellant in this matter of Doe v. Young, which essentially is Doe v. The Board of Trustees of the University of Illinois. This is a case where the plaintiff appellant was expelled from the University of Illinois following a Title IX complaint. There was a process at the university level. Obviously, we believe, and I won't rehash the facts that are offered in the brief, but we believe his due process rights were trampled over at the university level, but also subsequently, we believe his due process rights were violated at the district court level. Initially, we filed a complaint, well, the plaintiff filed a complaint against the University of Illinois. At the inception of the litigation, there was a corresponding petition to proceed under a pseudonym. The defendants were immediately notified at the time that the complaint was filed that the litigant or the plaintiff intended or wished to proceed under a pseudonym. The defendant, University of Illinois, counsel was contacted and they did not object or oppose. Obviously, it's our position that this was an agreed order or agreed motion at that time upon contact to proceed.
And Mr. Brown, what year was that there was that agreement?
Your Honor, this would have been in 2023, November of 2023 at the inception of the litigation.
Thank you. You may continue.
Thank you. And this was, obviously there were other matters at issue, being university student defendants as well as other students within students who are also a part of the litigation.
Mr. Brown, how do you respond to the evidence that was submitted by the university here that Jane Doe, who is the alleged victim of the underlying events, is not worried about the disclosure of her identity if your client has to reveal his true name?
Our concern is that position was not fully vetted. We think an evidentiary hearing would have been appropriate. I know that
You don't think the affidavit that represented that is sufficient?
we do not. We think an evidentiary hearing would have been appropriate. Certainly, Jane Doe was able to offer her position, and I think that was a position or an affidavit that was offered by the appellants in response to another case.
Do you dispute that she feels that way, or are you saying an evidentiary hearing is necessary to see if that's really accurate?
Absolutely, and to be vetted. I think it was a one-sided presentation that was offered, and the appellant, the appellee, their position is that the appellant didn't necessarily. The appellant had an opportunity to confront or investigate this. We vehemently disagree with that characterization. We think the appropriate vehicle to vet Jane Doe's position, especially considering Jane Doe is not a legal scholar, certainly not a lawyer, and so Jane Doe would be in no position, absent counsel, to make a determination that this court is to rely on whether or not there is any would be any potential harm, or specifically with respect to the ramifications of her position.
You don't dispute, Mr. Brown, that it is a relevant inquiry under our case law as to whether or not the disclosure of your client's identity could potentially impact her?
We don't dispute that, no, of course not.
If an evidentiary hearing were to take place rather than an affidavit, and she were to say, I'm not worried about my name being linked to John Doe's, what would your client's position be in that hypothetical scenario?
Not only my client, we believe our client would disagree with that assessment. We believe that if allowed an evidentiary hearing, we would be able to present evidence to controvert that, but also additional witnesses who I think would give the best perspective on what the reputational or the harm, the outside harm would be, not just Jane Doe.
So your request for an evidentiary hearing is broader than just a potential linkage between the accuser and your client. It's all of the aspects that might happen as a result of potential damage to your client.
That is correct, all of it, but not diminishing the Jane Doe aspect of it as well.
Isn't the potential damage to Jane Doe's reputation, isn't that really something that's up to her to make a determination on, though, not your client?
Well, it's up to the court to make the determination, and I don't believe Jane Doe can independently instruct the court on the legal principles that the court is to consider. Certainly, Jane Doe's position is something that is of great relevance, but it is not, Jane Doe does not have the authority or the power to dictate what the legal conclusions are of the court, absent diligent inquiry.
Mr. Brown, the legal landscape's been changing a little bit even as this case has been progressing. Because as you point out, November 23, positions are taken with regard to the pseudonym. Then we have our court has two decisions that have been issued involving Indiana as well as involving, I believe it's Loyola. All since this case, I want to give you an opportunity to respond to the way the law has been set forth in those two recent decisions.
Well, Your Honor, Doe v. Trustees of Indiana, the 2024 case that is cited repeatedly by the appellant, but also cited, by the appellee, but also cited by the appellant, and then also the Doe v. Loyola case doesn't change anything. There's no new precedent that is offered in those cases. Simply the appellate court and Judge Easterbrook reminding the litigants or reminding the courts that this is a relevant inquiry. But those cases are distinguishable from this case. In those cases, you did not have waiver of the pseudonym issue. This was essentially 8 months later after the appellees had agreed to proceed on the pseudonym. That's not an issue. This was an objected to issue in Doe v. Trustees. Also, this case was at the summary judgment stage of the litigation, so the facts were fully vetted. Here we are at the conclusion of the briefing for the motion to dismiss, which is contingent simply on the complaint. Also, in the Doe v. Trustees, there was a defined 1-year suspension. The facts are entirely inconsistent with the case that we have here at hand. There was a commingled dishonesty issue with respect to the litigant. The John Doe was I believe the court characterized him as being a medical student well into his adult years. Here, John Doe, the appellant, was barely an adult, if at all an adult, as he was going into he was in the first semester of his senior year. Also, John Doe and the Trustees of Indiana University did not raise the issue of physical harm.
Counsel, I want to get back to the evidentiary hearing issue. You suggested in response to one of Judge Brennan's questions that you think an evidentiary hearing is needed to assess any potential harm against John Doe. Was that specific request made below?
It was.
And where was that?
That would be in the joint status report where we're asking for the evidentiary hearing. And we believe the court, even without the request, but it is in the status report where we ask for the evidentiary hearing, and it's raised also.
Beyond the issue of identifying Jane Roe with respect to harm to your client? There's a distinction here, right?
Understood. So there may not have been an opportunity to raise the request for the evidentiary hearing subsequent to the briefing, but we did want an evidentiary hearing. That notwithstanding, we believe that the standard as provided by the court and in the Doe, not just the Doe v. Trustees of University of Indiana case, is that an evidentiary hearing is required. What the Seventh Circuit has said is there must be a careful and demanding balancing of interests, and considering that there is no objective standard, or that the Seventh Circuit has not defined the standard for evaluating these types of cases, I think it would have been, well, we certainly believe that it would have been more diligent, and due process would have been appropriate if there wasn't an evidentiary hearing. So we believe the district court was compelled for us to have an evidentiary hearing. We would like to reserve what time we have left.
Very good. That will be reserved for rebuttal. Thank you, Mr. Brown. We're going to continue now with argument from the appellee, Mr. Land.
Good morning, Your Honors. May it please the court, Peter Land on behalf of the defendant appellees. This is an appeal about a decision that was left to the district court's discretion, and the real question is just whether there was an abuse of discretion, and there was not in deciding the pseudonym issue. Our briefs address a variety of issues. I might just focus my remarks on some of what was just occurring in the argument with Mr. Brown.
Before you get there, Mr. Land, please,
Sure.
How should your initial consent to proceeding under a pseudonym impact our decision today?
So there wasn't any consent or agreement on the pseudonym issue initially.
No
There was
objection
There was
to
just no objection. And I don't think that should affect this decision at all. I think
Why isn't that sufficient for waiver?
I think the standards changed dramatically with respect to pseudonym considerations based on this court's decisions in the Loyola and University of Indiana cases. I might note, particularly in the Loyola matter, this court raised the pseudonym issue on its own during oral argument after summary judgment had been granted. The pseudonym issue had been decided years prior in that case, again in the same way without objection from the defendant university, and then the parties were directed to address whether that should remain the case, and the court decided that it shouldn't. We, on behalf of the university, took that issue to the district court after those decisions were issued to indicate that in light of those standards that the institution was asking the court to reconsider the pseudonym issue. So I don't think it's waiver. I think the law had been adjusted or clarified by this court.
What's the downside of having a hearing?
What's the downside of having an evidentiary
Having a hearing such as Mr. Brown is requesting?
I don't know that there's a downside of having an evidentiary hearing. This particular district court judge took this issue very seriously. We filed briefs. We appeared for a status hearing where there was argument and discussion about whether to have an evidentiary hearing or not. That was preceded by a decision or an order from the court indicating that it needed more information to determine if there was going to be an evidentiary hearing. So we appeared to talk about that. Then we were given 3 weeks at the plaintiff's request to prepare a joint status report and collect any additional information that might bear on whether an evidentiary hearing would be needed. And there wasn't any information in the joint status report that you were asking about that indicated anything other than referencing what Jane Roe thought, and the fact that what Jane Roe thought, which was presented in an email exchange between her and me, that she didn't have any concern that her name would indirectly be disclosed if the plaintiff's name were disclosed in litigation. So I don't think that it's a question whether there was a downside of having an evidentiary hearing. There was no need for one. There wasn't any indication presented to the district court judge about why you would need one, when the only issue that was discussed was the effect on Jane Roe, and Jane Roe had cleared that up herself.
How do you respond to Mr. Brown's argument that that representation alone is not sufficient as to Jane Roe?
I would start by noting that the district court has discretion to decide what is needed in order to assess that question. The Seventh Circuit's decisions, your decisions, particularly the Loyola matter that addresses the evidentiary hearing concept, does not require an evidentiary hearing. It doesn't explain what an evidentiary hearing might involve. It raises the question of factual development being needed on that question of what Jane Roe's risk is at the district court. And I think that the Jane Roes of the world are grown women who get to decide and explain whether they think they have a risk or not. I don't think that you need evidence from the John Does or other witnesses that contradict a particular person's position on whether their privacy will be limited or violated by disclosure of someone else's name. So I don't think that's necessary to go beyond if a Jane Roe indicates that she doesn't have any concern. And I would say this, there was no contrary evidence at all presented to the district court judge about what Jane Roe thought. There were 3 weeks of time between the initial status hearing and the joint status report being submitted where additional information could have been obtained from her.
Although in fairness, my guess is Jane Roe probably would not want to talk to John Doe's lawyer.
Honestly, I've been involved in other matters where that's not the case. So I don't know that that would be the case here. I don't believe there's any indication there was any effort to contact her other than our effort and the clarity that she provided. And again, it's the district court's discretion to decide whether to proceed with a pseudonym or not based on or whether to engage in an evidentiary hearing or not, or whether one's needed. And there wasn't anything in the joint status report or any information presented to the judge by either side about any issue other than what Jane Roe thought. You know, I just commented on a couple different issues. The concept of due process having been violated by the district court here and how the judge assessed the pseudonym issue, I think misses the mark. Again, the sequence of communications and opportunities that the judge afforded both parties was substantial on this issue. We filed briefs. We appeared after the judge had issued a decision indicating what the approach would be and the need for consideration of potentially having an evidentiary hearing. There was then discussion. There were then 3 weeks to submit information relevant to that question, and then a decision after that. I think that's honestly probably more due process than was necessary in terms of notice and opportunity to be heard about an issue. So I don't think that that carries any water. I think in total, you know, this court did set or clarify new standards for pseudonym usage by the John Does of the world who bring these Title IX cases. And the district court followed that case law, carefully reviewed the facts, and exercised discretion to make this decision. So I don't think there's any abuse.
Thank you, Mr. Land.
Thank you.
Mr. Brown, we'll give you 2 minutes for rebuttal.
Thank you, Your Honor. May it please the court?
Yes.
Thank you. Your Honor, we would rebut just with just a few pointed factors. One being that the court set new standards. The Doe v. Trustees of University of Indiana and the Doe v. Loyola case did not set any new standards. It was merely a reminder. I believe even the appellee cite cases from as far back as 2011, but even going back before that, going back to as far back as 1993, and so and also 1996. So to suggest that these are new standards, they are not new standards. I believe Judge Easterbrook was merely reminding the litigants based on, and even Doe v. City of Chicago from 2004, these were not new standards. I think it's important that I continue to point out that the cases that were before the court in 2024 and 2023 are distinguishable from this case, meaning that the underlying facts were further along and the court had much more information and data to work with. Being the limited scope of the case on this case, meaning that we were on the eve of discovery, I believe that an evidentiary hearing certainly would have been appropriate. But also the district court used terms such as it acknowledged the request for an evidentiary hearing, calling it a waste of resources. We believe that in and of itself, considering the Seventh Circuit standards, that it must be a careful and demanding balancing of interests. We don't believe that the court's description calling it a waste of resources, we think that goes to the abuse of discretion. Thank you.
Thank you, Mr. Brown. Thank you, Mr. Land. The case will be taken under advisement. Is it Dodich?
Yes, very good, Your Honor. Good morning.
And you can hear me? And
Yes, I can. Can you guys hear me?
we can. And Ms. Wallitzer is here in the courtroom. And I will
Great.
call the case. The court is next calling Appeal 24-1184, Solid Ground Transportation Incorporated et al. Versus Commissioner of Internal Revenue Service. We are going to begin with the presentation from the appellant, Mr. Dodich, who is appearing remotely.
Thank you. Good morning, Your Honors. May it please the court. Joseph Dadich, appearing on behalf of petitioner appellant. I'm here asking this court to reverse the tax court's dismissal of appellant's case and remand for further proceedings. After a November 2023 court order which invoked jurisdiction, but we believe the court erred prematurely, dismissing the case based on, and why appellant will prevail based on two reasons. Number one, the court erred in guessing at a factual determination related to tax years under audit. The government has argued that the statement 2013 and subsequent years, which was identified in two different notices about 5 weeks apart, was actually a Scrivener error. However, we in turn are contesting that, and we believe that the court erred. And one of the biggest reasons, I'd say, is that there's typically manager approval that has to occur. And so someone would have approved this. And so that's kind of one reason. And then this kind of ties into our second reasoning for why appellant prevails, is that we believe the court prematurely failed to allow notice and opportunity to review what's called the administrative record. What's unique with these cases with regards to the retirement plans is that the court bases decisions on the administrative record. And here, the only one that holds the keys are the appellee. The appellee has the obligation to file the actual administrative record at a future date and time. There's a period of time after the answer is filed. And so we in turn believe that that the court erred and abused its discretion by not even asking for the administrative record.
Mr.
And
Goddard, given that the
turn,
second petition is still pending, what is the advantage to your client of having the first petition pending?
yeah, I don't know. Well, number one, in that second pending petition, which is 8843 at the lower court, there's been no administrative record filed in that case either. And so really, we in turn want to ensure, and by the way, in that case, the tax years in question are 2018 and subsequent years. And one of our points of contention, at least to be able to get this right, is that the plan started in 2013. That's why that year is there.
But
And
hasn't the
routinely-
IRS, Mr. Dadich, hasn't the IRS represented that it doesn't seek to take action against your client for tax years 2013 to 17?
As it relates to to your point, Your Honor, in the second petition, that's 8843, I would agree with that, except there's an argument that's made in a number of these cases called substantial compliance, which means the appellant and petitioner in that case can argue that they substantially complied with 2013, 2014, all the way through 2017. And then if there's a minor issue in 2018, the appellant can actually make that argument. Well, they substantially complied with all the other years, Your Honor, and the court can weigh that evidence. And so that's kind of what I'm I guess getting at, is we want to make sure to get this right, that the years in question are actually part of the case, whether it ends up being in 8843, which ultimately, maybe that's ultimately what in turn happens. If the court were to look at the administrative record, which we in turn believe is the appropriate step, that the court should have, at a minimum, looked at the administrative record. And by the way, the appellant, I in turn am actually prevented from filing any type of evidence until the administrative record is filed. And as already noted, the appellee has the obligation to actually file it.
So the advantage of having the first petition pending to you is you assert that that's going to expand the record to include things all the way back to 13, even though the IRS is saying they're not going to audit 13 to 17?
Well, I'm not sure if the IRS has said that they didn't audit 2013 through 2017. Again, all this is based in the administrative record. Now, I happen to have been the attorney during the audit, so I just want to be upfront. It was about 4 years ago, and routinely, the IRS, the very first question they ask with their IDRs, information document request, is provide us all the documentation going back to plan inception, including all transactions that have transpired, trustee approval, and things like that. And so I don't doubt that the government in the second petition has somehow said, okay, well, now 2018 is the year that we're looking at. And I understand that's part of their argument. It's it's my contention that the administrative record may tell a different story, that it was actually 2013 and beyond, and ultimately the case may end up getting consolidated at a later date. We're just asking for, as it relates to our notice and our notice and opportunity, is to be able to at least look at the administrative record and
Have you
then let the
requested
court
the
make a decision.
administrative record in the second proceeding?
No, that's actually still pending, meaning the appellee about a month ago filed a motion for extension to file their administrative record. So in both the cases, just to clarify, there has been no administrative record that's been filed.
But you expect that appellee is going to file it in the second case. I assume that
Correct.
they're directed to. So why wouldn't that satisfy your need for the administrative record to make the arguments you're presenting to us now?
Well, I in turn have a lot of respect for government counsel, Ms. Wolitzer, of course, because the government, I shouldn't say change the date. I don't know, because I don't know what the administrative record says about the 2018 and subsequent years. To your point, Your Honor, I don't know if the government in their administrative record is going to lop off anything that was provided from 2013 to 2017. So now I'm in the situation where I have to now file certain motions related to similar arguments that we have here, and a court at that point in time, let's assume it gets filed later this year. And then I'm now looking at it going, well, where's the other years? And where's our substantial compliance argument? And then I file our motions, and the court says, well, why didn't you file this a couple of years ago? You should have. There's a potential that the court may not allow us to add to the record at that point in time, is kind of what I'm getting at.
So why not ask for it now?
Well,
In that second proceeding?
I've tried, Your Honor, in a couple, and this is possibly unrelated, because I don't know if I filed it in this case, just so the court's clear. The tax court has based the times that I have filed it to try to add to the record, Your Honor, I've had that motion dismissed. And I honestly, unless the court wants me to look it up, I will subsequent to our hearing here. The tax court cites to certain cases that the administrative record has to come first. I wish it wasn't that case, because I in turn would have already done this.
Thank you, Mr. Dodich. Would you like to reserve the remainder of your time for rebuttal?
Yes, Your Honor.
Thank you very much. Ms. Wolitzer will now move to you for oral argument on behalf of the commissioner. Mr. Dodich, you should be able to hear Ms. Wolitzer when she comes to the podium.
Thank you, Your Honor. May it please the court. Good morning.
Good morning.
I'm Rachel Wolitzer, representing the appellee, the Commissioner of Internal Revenue. The tax court lacked jurisdiction over the revenue agent report because it was not a determination under Section 7476. So this is a jurisdictional question. It's a legal question, and you look to the statute. Under subsection 1 and the flush language of 7476A, the tax court has jurisdiction to review, quote, a determination by the secretary, unquote, regarding the qualification of a retirement plan. The term determination is used 6 times in 7476. Under 7476B5, if the secretary sends notice of his determination being in quote, regarding qualification of the plan, no proceeding to challenge the determination may be filed, and then there's a time limit on that. Now, the June 22nd letter to Solid Ground attaching the revenue agent report was not in any sense a determination conferring jurisdiction on the tax court.
Ms.
Neither the
Wolitzer, I understand and appreciate the jurisdictional argument. Can you shed any light on why this is being pursued from a tax perspective? Like, what would be the benefit to having this second proceeding? the first proceeding move forward?
Well, there isn't any, Your Honor. This,
Putting jurisdiction aside, and again, I understand and appreciate that argument, but is there some benefit to solid ground transportation to have the first proceeding continue in addition to the second proceeding?
no, because first of all, the tax court did not abuse its discretion in determining that the earlier correspondence before the determination, finally deciding the qualification, the tax court did not abuse its discretion in concluding that the first case only related to 2018 and did not relate to 2013.
And Ms. Walter, I don't want to put words in Mr. Dodich's mouth, and I'm not a tax lawyer, but his argument strikes me as when the initial document request came out, it was for everything, which went back to 13. Then he has not yet been able to file the administrative record, and prophylactically, he is concerned, or his client is concerned, about creep, that this may get larger and longer and not have an ability to respond to any IRS investigation other than the second petition. Hence, proceed with the first petition because they want to make sure there's coverage. Do you want to respond to that?
Yes, Your Honor. The audit is complete. The examination is complete. The all the correspondence from the IRS said that the examination of the 2018 year was complete. So there's nothing that shows that the IRS is challenging the qualification of the plan for the 2013 through 2017 years. Every reference in all the documents is to 2018, except for those few isolated references to 2013. And the tax court had found and did not abuse its discretion in finding that those were Scrivener's errors. And it does appear that they were, because if you look at the revenue agent report, there were numerous references to 2018 in the cover letter, on every page of the report, in the header, in the subject line, in the beginning of the report.
You said few, you meant two?
No. There were a few isolated references to 2013. Really, in the revenue agent report, there was only the reference at the end. And then again in the IDR. So a couple in the whole course of correspondence. In contrast, the references to the 2018 plan year were repeatedly throughout the revenue agent report. And the IDR, even though it referenced 2013, it only requested returns for 2018 through 2021. If it had been based on a challenge to the earlier years, it would have requested the returns for those earlier years. So again, in both instances of the revenue agent report and the IDR, it was a Scrivener's error. Everything points to that. And the IRS...
Let me ask a question with regard to the jurisdictional argument again,
Yeah.
because time is short. There is a tax court decision, ADTC 292, High Adventure Ministries, Inc. versus Commissioner, which sets forth this jurisdictional limit that jurisdiction is limited to instances where the respondent has issued an adverse determination letter, or where, after a request by the organization and an exhaustion of administrative remedies, the respondent has failed to issue a determination letter. That's a 1983 decision. Is there anything more recent that sets that forth? It just strikes me as a 40-year-old decision here that's setting the bar.
In our brief, we cite some cases that talk about the jurisdictional issue and how to interpret 7476. On page 13 of our brief, Wenzel versus Commissioner, 707 F2 F2nd 694, and FCO Tool Company versus Commissioner, 81 Tax Court TC 976. Basically, there has to be either a determination, or if the taxpayer or the plan has requested a determination, but no determination issues within a certain amount of time. But it all revolves around this determination. There has to be either a request for determination, which there wasn't in this case, it's undisputed, or a determination. And
perhaps the law has not changed in the last 40 years. I'm just inquiring whether or not there's anything that's more recent on that point.
yeah, really, it might not be, there might not be a lot of case law because it's really governed by the statute. And because the statute is so clear that there must be a determination, seems to be a term of art. It appears 6 times in the statute.
Thank you, that answers my question.
Okay, thank you, Your Honor. So, in contrast, the March 2023 notice stated, "This is a final non-qualification letter." The letter contained detailed instructions for filing a tax court petition regarding qualification of the plan, and the instructions said, "Be sure to include a copy of this notice, the notice of determination, and any attachments with the petition." The June 22nd letter did not have any of that language or talk about filing a tax court petition. And also the March 2023 determination letter was signed by the Director of Employee Plans compared to the exam agent who signed the June 2022 letter. I think when you're talking about the tax court's discretion to dismiss this case on the ground of duplication, there's a very high standard for the plan to meet. This court's case, Serlin versus Arthur Anderson and Company, 3F 3rd 221, sets forth this standard. That dismissal of a case for duplication is reviewed for an abuse of discretion. As a general rule, a federal suit may be dismissed for reasons of wise judicial administration whenever it is duplicative of a parallel action already pending in another federal court. And then it sets out the standard for determining whether an action is parallel, and that is also accorded discretion to the district court.
Thank you, Ms. Wolitzer. Thank you. Mr. Dodich, we'll now move to you for rebuttal argument. We'll have 2 minutes for rebuttal, please.
Thank you, Your Honors. And, I really just want to, one item, this may be more of maybe a policy of the government having worked against the IRS and worked with them as well. We would think that there'd be one form number that says that's the final form. And then we know, okay, form number 1000, when you get that form, that's when you know the statute is invoked, you have the 90 days and whatnot. Unfortunately, I don't believe that there is a specific form. So I wanted to just reference. And then one point that Ms. Wolitzer brought up about the tax years, and that her comment that the government's not challenging 2013 through 2017, which is all fine and dandy, which would mean her counterpart at the lower level, which is Ms. Kim, would stipulate to that in the 8843 case. And then we in turn would resolve this case if they would stipulate to the statement that they don't challenge 2013 through 2017, and that's a statement of fact. Then we can use that and weigh, at a minimum, allow the court to weigh, again, on behalf of appellant, to weigh in our favor. And so I think that would easily resolve this. If the government is saying that they looked at those original documents and they saw nothing there, in fact, they didn't see anything until 2018, then it shouldn't be too far of a stretch to have the lower court, Ms. Kim, who works on behalf of the government with 8843, to say they will stipulate to this and put that as a stipulation and add it to the administrative record. So I would just finish with that. Thank you very much. I'll rely on my briefs and oral arguments unless there's anything else from the court.
Thank you, Mr. Dodich. Thank you, Ms. Wolitzer. The case will be taken under advisement.
Thank you.
Our third case today is submitted on the briefs. That's Appeal 24-1961, Ramirez Acosta versus Bondi. We are therefore going to move to our fourth case of the morning, Appeal 24-1969, United States versus Payne Randall. Mr. Roy, we'll begin with you.
Thank you, Judge. Good morning. May it please the court. Attorney Michael Roy on behalf of Appellant Payne Randall. This court should vacate the conviction and remand for a new trial with suppression of the evidence discovered at Randall's home. I want to start with what I think is the simplest argument or simplest error to point out is that the district court procedurally erred when it decided to credit the testimony of Officer Radecki and the other officers because the judge felt that she was bound to accept their testimony, even though the written order, I think, makes clear the judge did not actually believe the story. The way she framed the question is whether she was bound to accept a story that doesn't make sense. I also think the second to last sentence of the introduction in the opinion and order, the court has no basis to call these law enforcement officers liars other than its own misgivings. It concludes that it is thus so bound to accept their testimony. I think that's a legal error. The court's misgivings is absolutely a reason to discredit the testimony.
Isn't that argument taking it a bit out of context and just focusing on bound to accept? When you look at it in its entirety, the court questioned whether or not you could smell marijuana outside from that far away, but she said, I held a hearing. Every one of them came in here and testified. They testified credibly and consistently.
Well, and I absolutely... sorry, Judge.
So just looking at it, it's in its entirety. Why aren't you just taking that phrase a bit out of context or asking us to look at that in isolation?
Well, and I absolutely agree we can't read a written opinion like it's a statute or something and parse the language individually. But I think the more you read the entirety of the opinion, the more it supports our position. It's not just this introduction. It's throughout the entire opinion. It's later on, court says remains deeply skeptical. As the government concedes, the court went into the hearing because it didn't really believe the story. And then it says, well, I'm not particularly moved by what they said. It doesn't change any of the facts. So like nothing at the hearing had moved the needle one way or the other.
But didn't she specifically credit Radecki's olfactory excellence?
Exactly.
That's on page 7. She credited that, correct?
And I was actually about to quote that next because I almost read that as sarcasm. I mean, I think that goes towards, it's almost like jocular saying, how absurd is it, but I guess I have to accept it. It almost seems more like it's a policy determination, that it would be too politically of a third rail to say that 6 police officers lied at the hearing. And I think there's 2 impermissible reasons why the court was afraid to go that way. First, the head counting, 6 witnesses means should credit, and that they have special status as police officers. And I think neither of those are permissible as special considerations to adopt testimony just because they come off with a credible demeanor if the court doesn't otherwise believe it.
It's true you can't just count the number of witnesses, and we say that in jury instructions, but why isn't that more of a statement that just reinforcing the consistency and credibility support that it happened?
I think because in this case, the court kept saying it doesn't make sense. I remain deeply skeptical. Nothing that these officers said changed the facts that we had coming into the hearing.
Mr. Roy, let me get the benefit of your thoughts on some reasoning. Arguments in the brief go to number and profession of the witnesses. In the reply brief, especially page 7, there's the argument that you've offered here that when you look at all of the comments in context, and it's an incorrect legal standard being applied. And if there's an incorrect legal standard being applied, that should result in a reversal. However, there's also an argument that that would be waived because it would be in the reply brief. If it's waived and it's in the reply brief, we then engage in some kind of plain error analysis. If the district judge applied the wrong standard, or she muddied up the standard such that we're not able to ultimately rely on that we find there's an error, it would be an error of consequence because some evidence would have been admitted that should have been excluded. But I think the third element of the plain error analysis would be, is there a reasonable probability that but for the error, the outcome of the suppression motion would have been different? Isn't it difficult to make that argument on the third element of plain error, that the outcome of the suppression motion would have been different, giving her credibility findings?
So I have two parts, or two answers to that, Judge. So the first would be, I mean, I'm coming in as sort of a pinch hitter for this argument. So I also read the briefs with fresh eyes, just like you did. I thought the argument was apparent in the opening brief. Maybe I'll have to reread it again. I thought it was from the get-go. The court legally erred, thought it had to accept their opinion. Now, in the opening brief, it was, yes, said she thought she was bound because of volume and because of their status as police officers. I mean, I think my understanding is that's the same as what we're arguing in the reply brief. It's that, yes, like she legally erred and that she thought she was bound. The reasons why she thought she was bound was the number of witnesses and their status.
So you aren't challenging her application of the correct Franks standard. Is that fair?
Oh, that it has to be a preponderance of the evidence
that-
to show reckless.
Yes.
Oh, yes, I see. No, I think the reply there is a clarification that reckless disregard as well as perjury can be a Franks violation. That's more in response to the government's brief where it frames it as has to be a finding of perjury.
So you agree that the district court judge applied the correct Franks standard here. You just disagree on how she assessed the evidence, essentially? Is that
Well,
fair?
we disagree on the standards she used and the methodology she used to assess the evidence.
Okay.
But there's no disagreement.
But not the Franks standard.
No, that, like, I think clearly the judge understood that if she discredited the officers or found that there was misrepresentations in the affidavit, that it would have resulted in suppression. And that's also, I mean, the government agrees with us that if the judge had found that the testimony was not true, it would have resulted in suppression because there wouldn't have been probable cause, even though this was only one part, but we seem to be in agreement that overall probable cause required the smell of marijuana. I do want to just make another point regarding the sort of special status of the police officers. I think that the hypothetical I would like to propose that I think sort of points out the error the court made is, say it had been 6 co-defendants in a drug conspiracy who all testified the same way, and I mean, you come in thinking, well, this sounds ludicrous, but they all have really good demeanor on the stand. I think that the same analysis would apply here with police officers. There's no special status to police officers. Obviously, we cite studies. We cite that Posner dissent about studies about police officers lying on the stand. Our argument is not that those studies are evidence that these specific officers lied. It's just that everyone's on the same playing field. You need to assess their credibility just like you would assess the defendant's credibility.
Quick question. If we agree with you, why wouldn't count 1 stand involving the drugs that were intercepted in the initial package that had nothing to do with the smelling outside the house?
Sure, Judge. So I'd be happy to discuss the sort of harmless error issues on any of the counts. For count 1 in particular, the package. The package, again, didn't have his name on it. It was 2 pseudonyms on it. And Radecki actually, he testified at the hearing, the suppression hearing, that he looked up in the databases, the people at the address. Mr. Randall was not associated with the address. The only thing that actually then tied him to the package was the mail that they found inside of the house. They used mail identifying documents from the house. That's what they submitted as evidence of his residence to show that he was the intended recipient of the package. Now, likewise for the drugs in the car, Radecki also testified at the hearing that the surveilling officers, the surveillance team, they weren't necessarily able to recognize Radecki as he was putting things in the trunk. So again, it's the evidence from the house, identifying documents showing that he had all this other drug dealing paraphernalia that then tied him to the person putting the drugs in the car. And then lastly, with the 922 G1 count, the government already concedes that the 924 C count would have to fall because they said the guns in the house were the ones tied to the drug crimes. There was a gun in the car, yes, but there were 5 guns in the house. And there's no special verdict form saying which gun the jury thought about when it found him guilty of 922 G1. It seems very likely that the jury focused on one of the 5 guns in the house that the government was already telling the jury to focus on because those were the guns tied to the 924C charge. And I want to be clear, we're not saying it would be impossible for the government to obtain a conviction on some of these counts without the evidence from the house, but just on harmless error review and with the nature of the jury verdict form, we can't say that that necessarily would have been the same verdict. And I see I'm out of time.
Thank you. We'll give you some rebuttal time, Mr. Roy. Mr. Whalen, we'll turn to you for argument on behalf of the government.
May it please the court. Thank you, Your Honors. Nathaniel Whalen here on behalf of the United States of America. There's a line between being skeptical of an officer's story and being prepared to call the officer a liar. The district court was clearly on the skeptical line throughout these proceedings, but defendant didn't present sufficient evidence to convince the court to cross the line and find the officer a liar. That is the correct legal standard, and so we ask that you affirm the court's denial. I think Judges St. Even Maldonado kind of got to the main point at issue in this case right away, which is you have to read this order in total. Yes, the district court's rhetorical question at the beginning of the opinion suggests that she was skeptical and she had misgivings and she had reservations about, based on her own experience, can you smell marijuana in the circumstances where the officer said. But then she did what a judge is supposed to do and what a trier of fact is supposed to do, and she called the witnesses. And she heard from all 6 of them. They all testified consistently and credibly that they smelled the marijuana from up to 25 feet away. And the court chose to credit their testimony consistently and credibly that they were telling the truth. That is the reason to deny the Franks hearing in this case.
How should we read her statement that in order to find the officer had lied in the search warrant affidavit, quote, the court would have to conclude that all 6 committed perjury, and she just wasn't willing to do that? Why isn't that really a tallying, as Mr. Roy has argued?
Well, I think as a factual matter, that is true, that the court would have to find all 6 committed perjury because all 6 said we smelled the marijuana inside the house. And so if you're going to find that Detective Radecki lied, you, by extension, have to find that all 6 were lying about smelling marijuana in the house. Additionally, there's the fact in the search warrant affidavit that it's not just Detective Radecki who smelled the marijuana, it's the officers in the back of the house, including Lieutenant Smallwood, who testifies at the hearing. So if it's a matter of physical impossibility to have smelled marijuana at that house, on that day, in that instance, all 6 officers got up and testified to a story the court found was a lie, or the court would have had to find was a lie. So, and it's not a question of tallying, it's, as Your Honor said, it's corroboration. Right? A court's more inclined to believe a version of events when multiple officers testified to it, or multiple witnesses. And I'd like to actually go with Mr. Randall's hypothetical for a second about if 6 co-defendants testified. A court could certainly credit that testimony. 6 co-defendants testified, we smell marijuana outside the house, if the co-defendant said, we're familiar with the smell of marijuana, we've dealt with it a lot, we know it when we smell it, for lack of a better phrase. Because that's why you credit the testimony. It's not that they're law enforcement officers. It's not that they have the badge. It's what the court said. It's because they're all experienced in it. They're trained in the smell. That's kind of within the officer's wheelhouse. They have certainly a much better recognition of marijuana than I do, than I suspect, and maybe I'm speaking out of turn, Mr. Roy does, than I suspect Chief Judge Brady does. Right? They're dealing with it every day for years on end on a daily basis. They're the experts. And that's why when an officer comes in and signs a search warrant saying I smelled marijuana, that can support probable cause. But as we noted, there's a Ninth Circuit case where a lay witness testifies I smelled marijuana. And the court struck it because there's no evidence the lay witness was familiar with the smell of marijuana. It's that kind of initial foundation inquiry that makes them more reliable about this particular thing. Now, if we had 6 officers testify the light was red when it was actually green, that's not really within an officer's experience and wheelhouse. And so maybe their testimony as law enforcement officers is not entitled to special credit as to that particular factual scenario.
Counsel, I have a question about
Yes.
the smell. And reading the transcript, there was some inconsistency as to whether it was raw or burned marijuana. The affidavit talks about raw marijuana. I unfortunately don't have the experience of knowing what the difference in the smell is, but what do you make of those inconsistencies in the officer's testimony?
So I think they all testified the smell that from this hearing, they all testified the smell that they smelled at that house on that day was raw marijuana. I don't believe they testified that it was smoked. I think there might have been instances where they referenced their experience with smoked marijuana, but on that particular day, I believe the testimony across the board is that it was raw marijuana. And so I don't think there is an inconsistency. I do think that, well, I think as a matter of kind of law enforcement experience, the smells of raw marijuana and smoked marijuana are different. I think, most officers would testify as to that. And so that changes the calculus a little bit. I don't know which way that favors. I'm also not very familiar with the smell of raw marijuana other than kind of walking down the street. And so I think the law enforcement officers testified on this day it was raw marijuana that they smelled. Does that answer your Honor's question?
Pretty much.
Okay. Getting to Judge Brennan's question, I read the briefs differently than Mr. Roy. I read the briefs, the opening brief is saying that Chief Judge Brady committed a legal error by counting and believing their law enforcement officers. I think the reply brief raises a very different point of she misunderstood the correct standard, and if you disbelieve a law enforcement officer, you can't accept their story. I think that's a little bit hard to reconcile with, I think, what Mr. Roy said at the end, which is clearly the judge understood if she discredits an officer or finds they misrepresented the standard, she had to grant the Franks hearing. So I think it's a little bit hard to say Chief Judge Brady understood the law and she didn't understand the law at the same time. Maybe the argument is she misapplied the law in this case, and then I think that gets back to the question of you have to read the order as a whole. And so pages 1, 2, 3, 4, 5, 6, 7, 8, 9 are all part of this opinion. And on page 6, she says definitively, 6 law enforcement officers got on the stand and testified they smelled marijuana. The court finds that they testified consistently and credibly, and all 6 have extensive law enforcement experience. So she understood that she is finding credibly that they testified credibly they smelled marijuana. She believes their story. She has misgivings based on her own personal experience, which I think is fine. I think, as this court noted in Contreras and Collin, it's okay to be a little skeptical, but that's not the same as finding an officer lied.
So, Mr. Will, if you could play that out to plain error. Then.
Sure. Yeah. Well, I don't think there's an error at the front end because I don't think the court applied the wrong legal standard. I think if you look page 6 of the court's opinion, it finds that they are not lying. I certainly don't think it's plain on this record, and so I think the defense can't meet the first or second elements of the plain error standard of review. I think the inquiry can end right there. Let me quickly address, Your Honors, if I may, the question of recklessness. Chief Judge Brady knew that reckless conduct could give rise to frank suppression. I think that's a square peg and round hole in this case. The standard for recklessness is whether the affiant entertains serious doubts as to the truth of their allegations. I don't know how you can write in an affidavit, I smelled marijuana, and entertain doubts about that particular statement when you write it. It's either true or it isn't. That's the binary world that particular statement lends itself to. Now, recklessness, this court's applied recently, forgive me, I don't remember the case, where there's other information contradicting the officer's statement in the affidavit, and this court's found that he was reckless and not including that. That's where recklessness comes in. This is about lying, and he either lied or he didn't. So I don't think recklessness is really a way that this court could reverse. Unless this court has any questions on that, for the first 2 issues, I'd quickly like to address the harmless error review. As to count 1, as to all the counts, the felon in possession count, the possession with intent to distribute, and the attempted possession with intent to distribute, we think the evidence is overwhelming. Any jury would have voted to convict for the reasons in our brief. It's not just the letters in the house that tied Mr. Randall. It's the fact that he is also taking this massive amount of marijuana and methamphetamine out of his house prior to the execution of the search warrant and putting it in the car. It's the fact that the individual whose car he put it in testified that he's a drug dealer. It's in his jail calls where he says, yes, I had marijuana in the house. He concedes his guilt as to the other counts. That is what makes the evidence overwhelming in this case. It's not the fact that they found guns and other drugs in the house as it relates to count one. As it relates to the gun charge, we agree there was no special interrogatory, but that's not the question on harmlessness. The question is, absent the evidence, would any reasonable jury have voted to convict? And we think the answer is yes, based on the guns in the car that the officers did see him take out of his house and put in the trunk. Same thing with the drugs in the car, and we know the jury found that he actually possessed with intent to distribute the drugs in the car, because we said the only way you get to the special interrogatory 50-gram threshold is you got to aggregate the guns in the car and the guns in the house, and they reached that threshold. So they clearly found that he possessed with intent to distribute the guns in the car, or the drugs in the car. And there would need to be resentencing on that, because if you exclude the drugs in the house, we do get below that 50-gram threshold. One final point, Your Honors, and then I'll sit down unless the court has any questions. I want to make sure we're not misconstrued as conceding the 924C count would have to go away on if this court were to reverse. He should be retried on the 924C count because he could be convicted based on the guns in the car. The evidence, I just can't get up here with a straight face and tell this court the evidence is overwhelming as to the 924C based on the gun in the car. But that is a basis for conviction. I don't want it to be construed as us waiving that there is sufficient evidence for this case to be remanded on that particular count. Unless this court has any questions, we would ask that you affirm.
Thank you, Mr. Whalen.
Thank you.
Mr. Roy, we'll give you 2 minutes for rebuttal.
Thank you, Judge. I want to start briefly with talking about the sort of training and experience arguments about that the court was more focused on their special ability to recognize marijuana than the fact that they were police officers. The Ninth Circuit case that the government was referring to, De Leon, that involved a dispute about whether they could specifically smell like a grow operation as opposed to cured or prepared marijuana. So it's different facts. We are not contesting their ability to recognize the smell of marijuana. I don't really see how the training and experience comes in. I have no doubt that Officer Radecki knows what marijuana smells like. The issue is whether, as a factual matter, the odor was there at the time. There's no training experience that turns him into a bloodhound, right? On top of that, if you actually look at the suppression hearing, Radecki describes the training he received, and it was basically, they showed us pictures of marijuana and I learned the smell on the job. It's not like he has a super nose. Regarding the sort of plain error issue you were referring to, Judge Brennan, I just want to emphasize, I think there's multiple legal issues at play in this this Franks hearing, just as there is in almost any hearing. I'm sure Judge Brady understood the Franks standard. The issue was that she misapplied the standards on how to assess the credibility of the officers. I think that was made clear in the opening brief as well. I'll point to the heading on page 9 of the opening brief that asks whether, by deciding the court was bound to accept testimony that doesn't make sense, the district court erred. That is the argument. Lastly, I want to touch once more on the harmless error issue. One thing I didn't get to in my opening talk is part of the harmless error comes from the propensity effect as well. Once the government has proved beyond reasonable doubt that he had not just drugs in his house, but multiple guns, as everyone knows, is often argued to be associated with drug dealers, scale, vacuum sealer, grinder, all sorts of paraphernalia. The drug was primed. They already knew he was a drug dealer. It was much easier for them to find the other counts too. Thank you.
Thank you, Mr. Roy. Thank you, Mr. Whalen. The case will be taken under advisement. Our fifth case of the day, Appeal 24-2068, Rainey versus Lewis, is going to be submitted on the briefs. We will move to case number 6. This is Appeal 24-1694, Kelsey Smith versus Michael Witzel. And Mr. Atkiss, we're going to begin with oral argument from you.
Good morning, may it please the court. My name is Michael Atkiss. I'm Here this morning on behalf of defendant appellant Michael Witzel, asking the court to reverse the district court's order denying him qualified immunity on the plaintiff's section 1983 claim for denial of medical care to Dalen Key while Miss Key was a pretrial detainee in the Macon County Jail. Key's death was tragic, and her estate will not be without a remedy regardless of the outcome of this appeal.
And why is that?
Still pending in the district court are Section 1983 claims against Nurse Dowdy, Nurse Jacoby, and Dr. Kosterison for inadequate provision, constitutionally deficient provision of medical care, as well as medical malpractice claims against those three defendants and Doctors Ray and I believe also Nurse Amanda Thompson.
Are those medical malpractice case claims supplementary jurisdiction state law claims?
Yes, they are medical malpractice claims under Illinois in the case pursuant to supplemental jurisdiction under 1367.
Very good.
The qualified immunity question in this appeal requires the court to examine the rules of law concerning a non-medically trained correctional officer's constitutional duty to take action concerning the medical care of a pretrial detainee over whom he's responsible. The court's precedents establish two different rules. First, there's a general rule that a correctional officer must summon medical care for a detainee who is in obvious distress from a serious medical condition. And second, there's a more specific rule that where there's division of labor between non-medically trained and medically trained staff at the jail, the non-medically trained officer's duty to act arises only when he has reason to know that the medically trained staff is providing inadequate care.
Didn't your client admit that under the division of labor, he was required to observe Ms. Key here?
Sure, and he was certainly required to observe her.
And is there any evidence that he saw her get medical care during this critical time period?
I think it's undisputed that she did not, well, I mean, I guess it depends, Judge, on how you, how broadly or narrowly you want to define medical care.
Any care from a medical provider, other than the one nurse who looked through the window and didn't go in to give any care?
No one specifically examined or assessed Key during Witzel's shift. That's an undisputed fact. That
And he never, your client never reached out to any medical staff to say, hey, she's getting worse, you should come check on her. I think that's undisputed
that
as
is
well.
also undisputed. The appeal involves the legal question under what circumstances one of the two rules that I mentioned earlier applies to the exclusion of the other. It's our position that the district court made an error of law when it applied the broader duty rather than the narrower one to the undisputed historical facts of this case.
Mr. Schlosser will argue that there are genuine issues of material fact precluding us reaching the legal question, and therefore this appeal should be dismissed. Can you explain to us why you believe there are not issues of fact?
Based on, I think you're referring to the jurisdictional issue.
Correct.
Sure. The defendant is conceding all facts in light most favorable to the plaintiff. And under those historical facts is where we still, undisputed historical facts, we still believe we're entitled to qualified immunity under that set of facts. It's not my intention to dispute anything that anyone says that's not favorable to my client here. I'd say this isn't the type of case where qualified immunity depends upon whether the plaintiff reached for his gun before an officer fired. That kind of case is oftentimes qualified immunity would be tied up in a factual dispute. But here the historical facts are undisputed. Specifically, and I pointed out and tried to clarify in pages 3 and 4 of my reply brief, those facts that I'm pointing to that we posit should place this case within the ambit of the more narrower, or the sometimes shorthanded, the medical deference rule. And those facts are, by time Correctional Officer Witzel ever had any responsibility over Dalen Key, two doctors, Dr. Ray and Dr. Kosterson, had already issued orders concerning her care.
Do you dispute, and we have the video evidence, do you dispute that a reasonable jury could find that the time period leading up to her death, that she was in obvious distress at that point?
I would say if the court decides that that general rule is the one that should apply rather than the medical deference rule, then there's a question of fact.
Okay, so
For
if
trial,
that, the rule that your client had some responsibility to act if he saw her in obvious distress, you agree there's an issue of fact on that?
Yes.
Okay.
Yes. The facts, the doctors had issued orders. The nurses had provided Key with medications pursuant to those orders, and Nurse Thompson had taken steps to have Key removed from general population to the medical observation cell just the evening before her death. At the very least, I think there's no existing precedent under such historical facts that would clearly establish that the broader duty applies instead of the narrower one, which plays into the clearly established, or the second prong of the qualified immunity analysis. I do see I'm into my rebuttal time. So
If you'd like to reserve the remainder, that's fine.
yeah, unless there's any specific questions right now.
No, thank you, Mr. Atkins.
All right, thank you, Judge.
Mr. Schlosser, will move to you now for argument on behalf of the appellee.
May it please the court. My name is Fred Schlosser. I represent Kelsey Jill Smith. She is the administrator of the estate of her deceased 21-year-old sister, Daylin Key, and she also in a representative capacity for Daylin's 2 minor children. The first thing we should do is look at the brief and the concessions made by Macon County and Correctional Officer Witzel. At page 9, while Witzel had the opportunity and means to observe Key's persistent vomiting and, quote, other physical distress over the course of several hours, he had no training on the signs, symptoms, or health risks of opioid withdrawal. Then it says, they admit at page 9 of their brief, opening brief, during his shift, he never saw any medical staff physically touch Key or take her vital signs, nor did he ever communicate any observations or concerns about Key's behavior to any medical staff. That goes to, Your Honor, St. Eve's questions about what the factual record says. But before we get to that, we should talk about the training. I don't like to read, but when it comes to training and policies and procedures manuals, you gotta be precise. The County Jail Policies and Procedures Manual that bears Crossing Healthcare's crest, and it bears Macon County's crest. On page 1 of that manual, it sets forth the division of labor with respect to health care to inmates in the Macon County Jail. It recognizes on the first page of an extensive manual, the delivery of health care to detainees is a joint effort of custody and healthcare staff and is best achieved through trust, cooperation, and open communication. It goes on to give examples of what types of conditions may need communication. It lists diabetes. We've all seen the diabetes ketoacidosis cases in the inmate setting, but it also says withdrawal from alcohol or drugs. That's the situation we have here. It's approved by the chief medical officer, chief executive officer, and the board chairman of Macon County. So that applies to both the security guards as well as the health professionals. Now, the jail policy, that manual describes what Trod 2 officers' responsibilities are. In this case, Correctional Officer Witzel was in charge of the Trod 2. The Trod 2 has a general population segregation inmates they look after, but also every inmate in the medical cells, of which there was only Dalen Key at this time. He has a responsibility to do a inmate count. That's at the beginning of his shift and at the end of his shift. That's a security function. Are the inmates in the facility? But there's another component to his obligations and responsibilities, and that is welfare checks. And those welfare checks must be conducted at a minimum of every 30 minutes. And those welfare checks is to assess the overall well-being of the inmate. That has a medical observer component to it. And it describes in its policy manual, well-being checks are intended to verify the safety and health status of an inmate. Pay attention to movements, breathing, etc. to make sure the inmate is okay. Security cameras may be used to assist routine monitoring of inmates, but they are not a substitute for physical well-being checks. Those were his obligations. That's the division of labor as set forth, not by the court when they're in an abstract or in a correctional facility. That's by the participants here, Macon County and Crossing Healthcare.
But we know, Mr. Schlossler, that jail policies can't set the constitutional floor. I understand you're arguing this in part, that this creates an issue of fact, but that can't set what the constitutional division of labor is. So if you would address Mr. Eckes' argument that under the case law and what the constitutional division of labor requires, that he should prevail here.
Okay, under the case law, and I believe you were a justice on the Parsano versus McGee opinion of a Michael Carter death that occurred in Decatur Memorial Hospital, if I'm not mistaken, in Macon County. Their policies were changed after the death of a previous inmate. In fact, Macon County switched from Decatur Memorial Hospital to Crossing Healthcare. But I think in answer to your question, the division of labor, the question here is under medical care and whether Officer Witzel should have the safe harbor, I call it, of medical deference. No, because under the medical care is not just abstract. The courts are clear in the previous cases where they found qualified immunity that we got to look to the serious medical need and the time frame of the interaction between jail guards and medical health care. In this case, he had an obligation to communicate. He doesn't have to be a doctor. He doesn't have to be trained. He doesn't have to do anything. You've seen the video, hopefully. It doesn't take anyone with any medical training to see that she was in serious medical need. The division of labor is if he wants the judgment, the medical judgment deference, and basically escape liability, that's what it does, he's got to communicate that. Nurse Dowdy, LPN Jacoby, he didn't say anything. He went in there, he fed her tray at 5:17. After watching her vomit for a couple hours, he gets on at 2:30. He talked to one of his colleagues, Derek Flower, and says, I got an inmate throwing up, and he was instructed by a guard, watch her closer. He's supposed to monitor by video. He's supposed to monitor physically her health and welfare. He didn't do so. He observed her. He knew she was throwing up. He went in and gave her tray and watched her laying on the vomit-soaked floor and crawl across the cell and onto her bunk. Saw two full trays from her breakfast and her lunch. She hadn't eaten. She's been vomiting. She can't even stand up. He doesn't even say anything. He didn't communicate anything. Now, Justice St. Eve, you mentioned
Judge.
she rolled, pardon me?
Judge St. Eve.
Judge, I'm sorry.
Thank you for the promotion.
Maybe that'll help. I don't know. Judge St. Eve, you mentioned that the nurse rolled over. That's not a factual of what she saw. You can't see it on the video. there's no indication that there's a communication between Officer Witzel and Nurse Jacoby. She denies that she was ever told that there was a problem. And she also denies that it's not her job to have the inmates' medical cells up on her monitor. In fact, it's not her practice, even though it has the capability. And I think as far as the case law goes, Kramer is helpful. Correctional officers got qualified immunity in Kramer. But there was communications, there was active involvement between the medical staff, the nurse in particular, and the inmates. They notified the nurse to seizure activity they observed. Now, she said, he's faking. And she said, and when they asked about vitals, his numbers are better than mine. They should be able to defer to that judgment, even if it ultimately turns out to be not acceptable.
So if we conclude that there are genuine issues of fact that would preclude jurisdiction for this appeal, and the matter were to go back and those issues of fact were to be sorted out, then the concept of qualified immunity might still exist. It's just within the judicial purview, and it's done after those fact issues are resolved. Is that correct?
I think it could be left up to the jury of whether qualified immunity is still on the table.
I don't think that's correct. I think the jury may resolve fact issues, but ultimately it's the
The
trial
judge, right. Well, I mean, they determined the factual issues. Qualified immunity is a legal principle determined by the court. On these facts, the judge couldn't determine it based upon the misapplication of the facts. But back to Kramer, there they avoided liability. They did what they could. They got help. They got assistance readily available. Now, the assistance wasn't effective, but that can't be on the correctional officer. Here, he did nothing. And Kramer clearly states that you cannot, the duty is you cannot ignore. As far as the clearly established law, Dobby versus Mitchell-Lockshee, it states in there, both the correctional officer and the nurse were both denied qualified immunity. It's not a zero-sum game. It's not a Venn diagram that doesn't connect. They can both be liable. And in this case, they are. And the jury should be able to determine that, or determine one is versus the other. I see my time is up.
Thank you, Mr. Schlosser.
Thank you.
Mr. Ackes, we'll go back to you now for a rebuttal argument.
Thank you, Your Honor. Just a few points. That, incidentally, I don't think I've ever seen a more real-life example of when you have the law, argue the law, and when you have the facts, argue the facts, than I think we're seeing in this appeal. Unsurprisingly, I prefer to talk about the law here. Counsel is arguing that communication between the correctional officer and the nurse, it seems like now counsel's conceding that that nurse was providing care for Dalen Key. The deference rule requires as a precondition communication between the CO and the nurse. That's not clear from this court's cases. The cases say that when the inmate is under the care of medically trained professionals, that the CO's duty is not to communicate obvious distress to the nurses. The CO's duty is only to take action when he has reason to know that the nurses or doctors basically are dropping the ball and not doing their job, which is an extremely high burden that, without some sort of evidence that a CO knew the particulars of a specific course of treatment or whether that treatment was being followed through on, I think is hard to say. A couple seconds about Dobby, since that's the case that plaintiff relied upon in his brief and the case cited by the district court. I think Dobby's factually distinguishable because what we have the facts I'm pointing to here were conspicuously absent in Dobby. In Dobby, there was no doctor had put down any order for Mr. Dobby's tooth abscess. No doctor had prescribed any medicine to treat that abscess or the pain that Mr. Dobby was experiencing. No nurse had administered any medicine. So when Mr. Dobby says to the correctional officer, "Can I see a nurse? I'm in pain here," then we're still within the ambit of the general rule.
Thank you,
See
Mr.
my time
Atkiss.
is-
Thank you very much.
Thank you.
Thank you as well, Mr. Schlosser. The case will be taken under advisement. We'll move now to Appeal 24-2539, United States versus Quinones. And Mr. Hammernick, we'll begin with you for your oral argument. Thank you.
Good morning, Your Honors. May
morning.
it please the Court. My name is Jared Hammernick, and I'm here on behalf of Joseph Quinones. We think the District Court committed two procedural errors at sentencing in this case, and that those procedural errors led to a substantively unreasonable sentence. We would ask this Court to vacate and remand, and I'll do my best to reserve 2 minutes for rebuttal. The first procedural error that I think we see in this case is the District Court's failure to explain in an adequate way why a 150-month sentence was the appropriate sentence for Mr. Quinones. The District Court, we think that the District Court's explanation fell short in a couple of ways, but I'd be happy to address any of those arguments that we've made in the brief. The one that I'd like to focus on this morning is the point that the District Court did not engage with the parties' well-founded arguments for a lesser sentence.
Didn't she ask, though, at the end, have I addressed your arguments of mitigation? And counsel below, who was not you, said yes.
Yeah, absolutely. We're not raising a Cunningham error arguments in this case. The government, sort of points it out, and we don't have a problem with saying that any sort of Cunningham-type argument is waived. Our point is a different one. Our point is that the District Court, in its explanation of the sentence, has to engage, at least to some degree, with the parties' well-founded arguments for a more lenient sentence. And so that's the error that we see is in the explanation, not in the addressing of the acknowledging the arguments that have been made. Undoubtedly, the court did that before it imposed sentence in this case.
How is that any different? You're saying error in the explanation rather than addressing them. Aren't you essentially saying that the explanation wasn't sufficient and the judge didn't address it sufficiently?
Well, we're saying the explanation was not sufficient. We're not saying the court wasn't aware of or acknowledged the arguments.
But I guess under Cunningham, I'm trying to figure out where that line is, because it sounds like the same argument to me.
Sure, and I think there's some overlap in the line. I'm not trying to sort of be too cute with the court here, but I think the point is that cases like Lyons and Ferguson and Schaffner demonstrate that when the court is explaining the sentence and is not just acknowledging the arguments that the parties have made, the court needs to take at least some effort to explain why those well-founded arguments for a lesser sentence were not, how that factored into the analysis. Right?
So at the end, as Judge Brennan noted, the court asked, wasn't you, but prior counsel, whether or not the court had addressed your primary arguments in mitigation, and the response was yes.
That's right. And again, so I'm not taking issue with that.
You're just saying she didn't sufficiently address them.
No.
So where's the line there?
Sure.
Unless I misunderstand something.
So I think our argument is not about whether the court addressed our arguments. The argument is whether the court satisfied the legal principle that I think we see in Lyons, Ferguson, and Schaffner, which is to say that the district court needs to engage with well-founded arguments for a lesser sentence, even when those arguments come from the government. Right? That's what I think Ferguson stands for, is that when the district court chooses to reject the parties' arguments, which it has obviously the authority to do, and goes above the guidelines, at that point the court has to offer some engagement with these other alternative sentences. And that goes to the court's duty to explain itself, not necessarily its duty to engage with, or not to acknowledge the parties' arguments. And so
you're drawing a distinction between addressing or acknowledging on one side of a line and engaging on another. Is that fair?
I think that's fair.
And to you, engagement would mean some further explanation as to why the district court ultimately sentenced 24 months above what the government sought. Is that right?
Well, that would be our position. I think it's borne out in Ferguson and Schaffner and Lyons. Yes. Yes,
You
I
may
think that's the authority that we would cite for that proposition. You know, even
How
if
is this case different than U.S. versus Weaver, where we addressed essentially the same arguments? I know it's a non-published order and not precedential, but how is it different?
Sure. So it's different in a couple of ways. So in Weaver, we were making the argument that the court's procedure or process created unwarranted sentencing disparities, and that's not the argument. That's not the thrust of the argument we're making here. The argument here is primarily based on Lyons, Ferguson, and Schaffner, and this idea of engaging with these other available sentences. Available is the language from Lyons. And so we're just making a different argument, I think, in that regard. And so that would be sort of the primary points. I think we're just addressing a different question in this case. If I may, I'll turn to sort of our second procedural error here, which is that we don't think the district court adequately explained why it was deviating above the guidelines range. No doubt the court knew what it was doing. The court said that it was deviating above the guidelines range and said that there were justifiable reasons to do so. We don't think the district court anywhere in the transcript set out why what those reasons were, right? Not in any sort of explicit way. I think you could go through the transcript and pull out of context comments and offer those as the justifiable reasons, but the court didn't do that itself. And we think that Gall and Ballard are both decisions that suggest really the court is the one that bears the burden of articulating why an above guideline sentence is required. There are obviously, there's a lead up to that comment that there are justifiable reasons. We see that as the court going through and explaining, here are the different things that I'm taking into account, right? The way that I see those is those are building blocks, right? Those are building blocks to a particular sentence. But those building blocks can add up to various different sentences, right? Mr. Quinones had argued that those building blocks added to a 96-month sentence. The government argued that they added up to a 126, and the court seemingly disagreed and said, no, that's really a 150-month sentence. And that's obviously within the court's authority. But an explanation of a deviation from the guidelines range can't rely basically on spilling the box of Legos over and saying, look, there are justifiable reasons here. There are building blocks for the sentence, and then allowing appellate counsel in this court to sort out what are the reasons. What are the reasons that this sentence and this deviation is required? To my mind, that's appellate speculation, not appellate review. And that's why a remand is required so that this court can set forth those justifiable reasons. We don't really have any doubt that Judge Brady has justifiable reasons. I'm sure she does. But we don't know what they are. And I don't think we get to speculate after the fact. It's really the district court's duty to put those forth into the record and let us know what those reasons were. I think the last point that I would like to make here, before I get into my rebuttal time, is this. If the government's methodology here, in terms of reading the transcript, is correct, that you can, in essence, mine the transcript for statements that are favorable to one party's litigating position and then supply those as the justifiable reasons. To me, I think that actually is not a faithful way of reading transcripts fairly and as a whole. I also think it well could backfire, because I don't see what would prevent a person in Mr. Quinones' position from coming back and saying, hey, look, there's a Tapia error in this case. Now, that would not be our position, but if you can go through and pull comments out of context and say, hey, here are the reasons, then we could look at this transcript and see that the court was very concerned about Mr. Quinones' mental health concerns, his substance abuse, his alcoholism, and the court then went above and beyond what the parties had asked for and posed a longer sentence, and may have done so in order to account for those rehabilitative concerns. Now, again, we don't think that's the right way to read this transcript, but that's because we think the comments have to be read in the context in which they were made, and the context in which those comments were made was that the court was explaining what it was considering, not describing why it was doing what it did. With that, I'll save my time for rebuttal, if I may.
Very good. Thank you, Mr. Hamernick. Mr. Whalen, we'll move to you for argument on behalf of the government.
May it please the court. Nathaniel Whalen here again on behalf of the United States of America. The district court did not procedurally or substantively err in imposing this sentence, and so that we ask that you affirm. I I think the argument, as I understood it in the opening brief, was this court can't consider what the district court said prior to hearing from the parties. That was the argument in Weaver. That was the issue this court decided, albeit an unpublished opinion. This court noted in Weaver that Weaver insists that district court's initial discussion of the 3553A factors cannot be considered, and the court said we cannot agree. That's what this court decided. I don't think there's any reason to reach a different result in this case, and I don't necessarily hear defense arguing at this point you can't consider it. I think their position is more, and I don't want to put words in their mouth, that the district court's initial discussion was not actually a consideration of the 3553A factors, but was kind of an off-the-cuff comment that had the court committed, for example, a Tapia error, they wouldn't be coming back and arguing on appeal that that was a procedural error because that wasn't an analysis of the 3553A factors. Respectfully, I think they would be coming up and arguing there was a Tapia error had the court said at some point prior to hearing from the parties, you know, and I should make your sentence longer to account for mental health reasoning. But I think on the facts of this case, it's reading the transcript as a whole, which is a theme for me today apparently, the district court was saying it was considering the 3553A factors at kind of this initial discussion at pages 9 and 10 of the sentencing transcript, or at 9 and 10 of the appendix. The court's talking in terms of mitigating and aggravating factors. It's talking about the defendant's criminal history. It lists 9 of his prior convictions. The court talks about, as I considered all of the 3553A factors, it's signaling to this court, to the defense, to the government, this is its analysis of the 3553A factors.
It seems like that's a procedure this district court judge routinely employs. Is that fair?
That's fair, Your Honor. I think where I've seen her not do it necessarily is if there's further evidence from the parties, and I think that's an important distinction. In this case, as in Weaver, as I remember, there was no additional evidence when she fronted the consideration of the 3553A factors. You know, I think if a district court expects further evidence, she'd ask the parties, is there more evidence coming? I think if she expects different evidence, she sometimes holds back on her analysis of the 3553A factors because those can be affected by the evidence in the case. Here, there was no evidence forthcoming. And in fact, the arguments the parties made, both the government and the defense, were entirely consistent with everything they said in their sentencing memo. There really wasn't any new ground tread here. And so there was no reason for the court to go back and reconsider its analysis of the 3553A factors. In terms of kind of a different signal as to how you know that this is Chief Judge Brady's consideration of the 3553A factors is on page 27 of the appendix. She says, as I discussed in mitigation, when she's kind of imposing the sentence, the only previous discussion of mitigation is everything prior to hearing from the parties. So either she is just flat wrong and she never discussed something in mitigation, which I don't think is the right way to read the transcript, or she's reincorporating what she previously said prior to hearing from the parties. And I don't think there's anything wrong with that procedure, as long as the court keeps an open mind. And there's no evidence in this case Chief Judge Brady did not keep an open mind after hearing from the parties. As I understand the argument, we're no longer in kind of a Cunningham error. I think the defense rightfully acknowledges the district court, or he waived any argument the district court didn't consider and address as principal arguments in mitigation. I think the cases like Schofner and Lyons that he relies upon are concerned with the substance of the court's explanation and not whether it grapples with the parties' arguments. That's two different lines of case law. Schofner says that you can't say, I consider the arguments without more and then impose the sentence. Lyons says you can't give a rote statement and then impose the sentence. Those are about, did the court adequately explain, with reference to the 3553A factors, its sentence. And here, Chief Judge Brady did adequately explain her sentence. She referenced the defendant's 9 prior convictions, the recidivism rate that was kind of going one after the other, the fact that they're escalating in violence, the fact that the offense conduct in this case is him pulling a gun on a employee at McDonald's because they aren't serving French fries at 8:30 in the morning.
Does the Cunningham procedure, if it is followed, moot the Lyons and Schofner concern?
No, I don't think so, Your Honor, because those cases aren't about principal arguments in mitigation and whether the court considered it. They're about whether the court adequately explained the sentence.
So you agree with Mr. Hamrick that those are separate issues?
Yeah, I think a court, no matter, you can't insulate a sentencing by saying, have I addressed your principal arguments in mitigation, and then say a rote statement under 3553A. You have to adequately explain your sentence with regards to all the 3553A factors. And the problem in Lyons and Schofner is that the court didn't adequately explain the sentence. The problem in the Cunningham cases is the court didn't address the defendant's principal arguments in mitigation. We think the district court did appropriately and adequately explain its sentence with regards to the 3553A factors. And to be clear, Chief Judge Brady didn't only focus on the government's position, and I don't think our brief said that. To the extent that it did, I apologize, because we tried to note that she in fact considered the defendant's mitigation arguments quite extensively, actually, prior to hearing from the parties. And that was the defendant's main arguments. I'm sorry, I said mitigation, his childhood. His position was his childhood was a strong argument in mitigation, and Chief Judge Brady considered that. She talked about his homelessness, she talked about his abusive parents, she talked about his troubled childhood. That all happens at pages 8, 9, and 10 of the sentencing transcript, and then again, she reincorporates that as pages 27 and 28. Because she procedurally appropriately justified the sentence, I think that kind of knocks the substantive argument out of the way as well, because as I understand it, the position is because she gave no weight at all the 3553A factors, the appropriate 3553A factors, the sentence is substantively unreasonable. It's our position that she gave them adequate weight. This court shouldn't reweigh the factors, just confirm that she did give them enough attention and detail to satisfy the not particularly onerous standard of explaining a sentence. Unless this court has any further questions.
Thank you, Mr.
Thank
Whalen.
you. We would ask you affirm.
Thank you. Mr. Hamernick, we'll go back to you now for rebuttal argument.
I think our essential point in this case is that there's an epistemological void, right? We know what the court considered and we know what the court ultimately did, but we don't know why. We don't know that intervening epistemological question. Why, based on all those considerations, which point in different directions, right? You have 3553A factors that favor Mr. Quinones, and you have aggravating factors that favor the government. You have Mr. Quinones' really awful childhood that points in the direction of a lesser sentence, and I don't think you see the district court resolving the tension between those facts that point in different directions. And that's the explanation that's missing. So we agree with the government that there's a difference between acknowledging arguments of mitigation and explaining a sentence. What we think is missing here is that point, is the explanation was missing. I also didn't hear my friend on the other side address our points about the lack of explanation for the deviation from the guidelines range, and we think it's just very clear under United States versus Gall that you have to address that part of the sentence specifically. We don't think the district court did that, and so we would ask this court to vacate and remand for resentencing.
Thank you, Mr. Hamernick. Thank you, Mr. Whalen. The case will be taken under advisement. We'll move now to Appeal 23-3251, United States versus Gregory Johnson. And we'll begin with oral argument on behalf of the appellant, Mr. Roy.
Thank you, Judge. Attorney Michael Roy on behalf of appellant Gregory Johnson. This court should vacate the $5,000 assessment under 18 U.S.C. 2259A. I am going to do my best to avoid acronyms or alphabet soup or saying lots of statute numbers in this appeal, but I understand that I might slip up, and I'm happy to also adopt any terminology the court uses. But fundamentally, I think that the issue is pretty simple, even if it involves a lot of alphabet soup. The judge found that Mr. Johnson could not afford a fine. The assessment under 2259A adopts all of the same standards as is used to assess indigency for a fine. The judge was at minimum required to explain why the findings of indigency were different for the assessment as opposed to the fine.
Mr. Roy, do you agree that the statute, that 2259A, is mandatory and you're just disputing the amount the court assessed? Or are you challenging the mandatory nature of 2259A in the first instance?
I don't believe it is mandatory in the same sense that, say, some other statutes are mandatory, like the special assessment. The
How do you get
$100
around the shall assess language?
Because it also then goes on to say you must consider the financial status of the defendant. I think that makes it more similar to the 3013 assessment, which also uses shall language, but
Why doesn't
like
that go to the amount as opposed to the imposition in the first place?
I mean, I suppose there is a way to construe the statute that maybe if you find a defendant is truly indigent, you award nominal assessment. After all, like a lot of these restitution procedures draw from civil law, it's not uncommon to have things like $1 damages on a nominal amount of damages. So perhaps that is the construction, though I'm not aware of any court adopting that specific position.
There isn't a lot of case law out there, which I think you recognize in your briefing, but I don't know how you get around the shall language. The court shall assess. I think you have some arguments about how much that are make some sense, but in terms of imposing it in the first instance.
I think because the implication is shall assess after considering the factors under no, I'm getting caught up on the numbers under 3572 and under 3553A. If the assessment comes after considering financial status, there are going to be situations where someone cannot pay. I would
The
also
statute, I'm sorry to interrupt, but the statute in reference to 3553A and 3572, the two statutes I think you were just talking about, it specifically says in determining the amount of the assessment under this subsection, the court shall consider those factors, not in determining whether to assess in the first place.
Yeah. And the last thing I would do is contrast this to 2259, the restitution that is due to identified victims. This was a non-victim case, but if there is a victim, 2259 kicks in. That one is, Congress made sure to make it clear that that was truly mandatory. Sub B4 of that says in it, order mandatory is the entire subsection of that statute saying order mandatory. Subsection A of that subsection again says issuance of restitution under this section is mandatory. It's like the third time they're using mandatory language. And then subsection B says the court may not decline to issue because of economic circumstances. That language was not included in 2259A. So I think if Congress wanted to make 2259A mandatory in all cases, similar to 2259, it would have included similar language. However, even if this court does construe it as only going towards the amount, again, maybe he is owed $1 in restitution, then that would still require remand in this case. I do want to also just briefly highlight, along with the fine, of course, the 3014 assessment under the Justice for Victims of Trafficking Act. This court held in Otradovic that the indigency assessment under 3014 is basically the same as you would use under 2259A. So the court's finding that he's indigent under that statute, again, contradicts the assessment under 2259A. And so I think McIntosh, which is a case the government relies heavily on, really helps bolster our position. So in McIntosh, it was talking about the Mandatory Victim Restitution Act. The court doesn't need to explain separately for the Mandatory Victim Restitution Act because, like 2259, the MVRA has that language that says do not consider financial status. But they did say the Traditional Victim Restitution Act, which would be 3663, so section 3663, they would create a potential contradiction in the sentence if the judge did not explain why it was imposing it. And so that's more close to 2259A, which involves discretion in the same way that the 3663 restitution requires discretion. So like this court said in McIntosh, if the court were to find two indigent to a fine but impose a 3663 assessment, it would need to explain why. Same here. If the court finds two indigent to impose a fine but does not explain why imposing a 2259A assessment, that creates a legal problem. I apologize for all the numbers. I am happy to clarify anything, and I hope I didn't get any statutes wrong there.
Is there enough in the record based on the roughly $40,000 in the retirement account that would justify this? Or is your argument that the judge didn't make that link? Let me rephrase. If the court had said, I'm imposing a $5,000 fine here under 2259, or assessment under 2259A, because he has $40,000 in a retirement account, is that sufficient?
I think if the court did something like the in the 10th Circuit case Gentry that the government cites, where it's like, I am saying that he only has enough money for $5,000 in total, I'm going to put that towards the assessment and waive the fine, then we would be, arguing clear error, or probably would not be bringing the appeal at all in that case. But the PSR, it's mostly facts about his indigency, right? Other than the 401k account, which, of course, the government's right, can be garnished in some cases. There are additional considerations there, right? He can't access the 401k now, at least not without a substantial tax penalty. It's not accessible in the same way as his other funds. It's not like his bank account or income, or I guess non-income at this point. The court would have needed to say more. And what the court did say, under, again, the same factors that apply here, is based off of what's in the PSR, he can't afford it. So that would be our link there.
Thank you, Mr. Roy. You'll reserve the remainder of your
All right,
time
thank you,
for
Judge.
rebuttal. We'll now move Mr. Temkin to you for oral argument on behalf of the United States.
May it please the court. Good morning, Your Honors. Eli Temkin for the United States. This court should affirm Mr. Johnson's judgment. The district court followed the law in imposing the Section 2259A assessment. The court adopted the PSR that set out sufficient findings. The court considered the correct factors under the statute. It recognized that the assessment is mandatory, although the amount is discretionary. It imposed an assessment within the statutory range and at a level that was substantively reasonable, and it provided an explanation that was sufficient, even if it was brief. Mr. Johnson seems to be arguing two things, really. First, as to the substance, he seems to argue that the district court's findings compelled it not to impose the 2259 assessment, or put differently, that the court could not impose any amount above $0. He also takes issue with the court's explanation. He seems to argue that the court didn't justify imposing this $5,000 assessment, given that it found Mr. Johnson indigent under Section 3014 and unable to pay a fine. Neither of those arguments is supported by the record or the law. First, Judge St. Eve, you are absolutely correct in characterizing this 2259A assessment. The assessment is mandatory. The amount is not mandatory, but the assessment, the statute says the court shall impose this amount, shall impose this assessment. In that sense, the language is similar to the Section 3013 assessment, which is mandatory, as we pointed out in our brief under, for example, this court's Filson case.
If it is mandatory, where does the $5,000 figure come from? What's the explanation for that figure?
In this case?
Yes.
The explanation comes from the PSR that set out sufficient findings that address the 3572 factors, and from the court's consideration of the 3553A factors.
But couldn't the PSR justify any number between 1 and 40,000? Is there something specific about the 5,000 that the PSR points to?
It would be up to 50,000 under the statute.
Okay.
But
he only had 40,000 in retirement funds, though, right?
Correct. 40,000 in retirement funds, and then I believe $500 in a savings account. But yes, up to $50,000. Nothing in the PSR sets the $5,000 amount. That was the court's exercise of its discretion.
That's the question. Where does that come from? The PSR doesn't give an explanation for why 5,000 as opposed to 500, as opposed to 10,000. And can you address that?
Yes, Your Honor. The PSR has the facts about his ability to pay, which is one of the considerations under 2259A, along with the other 3572 factors and 3553A factors. But the PSR does not set that amount. The district court set that amount. The court could have imposed up to $50,000. The court chose not to do that. It assessed everything, and it determined that $5,000 was the right number.
So in looking at it for clear air, given all of the other findings about him being indigent, how can the $5,000 stand?
Yes, Your Honor. Mr. Johnson recognizes a court can impose one of these financial consequences, penalties, assessments, whatever you want to call them, but not the others. And the statutes prioritize this 2259A assessment above the other penalties that he's talking about. So Section 3014B says, that's the Justice for Victims of Trafficking Act, that expressly says that that amount is paid after any victim-related compensation payments or something to that effect. And so that puts 2259A above that. The 2259A statute itself in subsection D2 sets up the order in which funds are to be dispersed. And that also indicates that Congress intended money to flow from this 2259A assessment before the 3014 assessment under the Justice for Victims of Trafficking Act or before a fine. So the court was adhering to the direction that Congress provided. There's also nothing inconsistent with finding Mr. Johnson indigent under Section 3014. Section 3014 sets out a binary determination. Is this defendant non-indigent? If the defendant is non-indigent, then they have to pay this $5,000 amount that's set out under statute. End of story. Section 2259A is different in that it directs the court to consider a host of factors under 3572 and 3553. So it's not just a question of whether he's indigent. In this case, the amount the district court determined was well within the bounds of reason. Mr. Johnson had the ability to pay this amount given his retirement account. He has no dependents. He has no need to pay restitution to any individual victims. The 401k funds are available under this court's Syed case, and as another example, the Fourth Circuit's Frank case. It doesn't get him out of that he's younger than he would like to be to access his 401k funds. A potential penalty doesn't exempt those funds from paying restitution to victims of child pornography offenses. The court exercised its discretion in setting this amount well under the maximum. It also waived interest on this amount, which further indicates that it was thinking about this amount and how much Mr. Johnson could afford to pay. It's not inconsistent with the Section 3014 assessment. And Mr. Johnson does not identify any court that has held that a finding of indigency under Section 3014 precludes imposing a Section 2259A assessment. To the contrary, the Second Circuit's, these are unpublished, but the Second Circuit's Gentry case, it affirms the imposition of a 2259A assessment even while the defendant was indigent under Section 3014, and the 10th Circuit's Hughes case, both of which we cited in the brief, affirms the imposition of a 2259A assessment even while the defendant was unable to pay a fine. As to the explanation, a district court does not need to make an express or specific finding for each of the relevant factors, and that's the case under a number of this court's decisions. For example, Lee and McLaughlin that we've cited in the brief, especially in a case like this one where no party is raising the issue. The district court can make sufficient findings by relying on the PSR and adopting the PSR, which it did here, and considering the correct factors. Mr. Johnson seems to agree that adopting the PSR can support the district court's determination. He acknowledges that on pages 4 to 5 of his reply. The court again considered the correct factors. As to the cases about imposing one financial consequence but not others, this court's cases in McIntosh and Bell, for example, set out how to think about this. If two payments or two types of payments share the same status and the court imposes one while finding a defendant unable to pay the other, it has to explain that. But in this case, these payments don't share the same status. 2259A is prioritized above Section 3014B under both of those statutes, and under the text of 2259A subsection D2, it's prioritized above a fine. In McIntosh and Belk, granted the question was about consequences that were mandatory versus discretionary, but the same principle holds here, that where Congress has supplied the rationale for elevating one payment or type of payment above another, the court doesn't need to repeat that in every case, as this court expressly said in McIntosh. Finally, if this court were to find an error, if anything, it should remand to the district court, a limited remand, to address this under what the court determines is the correct analysis. The government is not looking to introduce new evidence, like in the cases Mr. Johnson cites in reply. We ask the court to affirm.
Thank you very much, Mr. Temkin. Mr. Roy, will move to you now for rebuttal argument.
Thank you, Judge. I do briefly just want to make the point that our position is not that the PSR mandated a finding of evidentiary or that it mandates either side's position. I think thinking about, for example, the 3014 assessment, the one that's not at issue, but the one he did find indigent and said, oh, I considered future earning potential. That could have gone either way. I mean, he's a skilled laborer. He was working in, I forget what exact type of factory. And then, of course, the defense rebuttal is like, who's going to hire him after this conviction? And so the judge made a finding about what it was. And here, it's the judge's findings were already made. That's why our argument is that it's de novo review instead of clear error. It's the judge misapplying the statutes and not applying the same standard for both the fine and 3014 as against the 2259A assessment. I also want to address the government's argument about priority of the different, I'm saying criminal penalties, even though I don't know if they're all strictly penalties under like 8th Amendment jurisprudence. There is in the statute rules about the disbursement of the different monetary amounts, right? So that 2259A assessment gets dispersed before a fine, gets dispersed before other things. But it doesn't say that they get imposed in a specific order. And I think that's a key distinction. Subsection D2 of 2259A directs the court not to consider other fines and assessments. It's supposed to consider it in isolation when it imposes the assessment under 2259A. It's not supposed to impose it with regard to how that is going to affect the other ones, which I think undercuts the government's sort of priority or like waterfall argument about how these different assessments should be done. And unless this court has any additional questions, I will see the rest of my time.
Thank you very much, Mr. Roy. Thank you, Mr. Temkin. The case will be taken under advisement. We'll move now to our final case of the day. This is Appeal 24-1827, United States versus John Sand. And Mr. Reed will begin with oral argument from you.
Judges, and may it please the court, Peter Reed for the United States. Traditional health insurance defines a customer's costs and shifts the risk of high medical bills to the insurer. The telemarketing outfit where defendant John Sand worked as the vice president of sales made customers think they were getting something similar to that. But in fact, they were selling limited indemnity policies, which limits the insurance company's costs and has no risk shifting and no out-of-pocket maximum. That's why they're typically supplemental policies, not primary policies. The jury found that that was fraud and convicted Sand on all counts. Sufficient evidence supports sending that case to the jury on the issue of intent for the many reasons outlined in the briefs, a few of which I'll focus on today. The first is that any rational trier of fact could find, based on the co-conspirator testimony at trial, that Mr. Sand had the requisite intent. The testimony of the co-conspirator, another executive, Ms. Gerard, in this case was frankly very black and white. She was asked, what was the fraud being committed at this company? Well, it was deceptive sales practices through the use of misleading sales scripts. Who did you conspire with to commit that fraud? Well, the defendant, Mr. Dorfman, the defendant, Mr. Sand. You have that kind of testimony on the record, and you have a jury verdict, and you're under Rule 29, that's the end of the game. And that's what this court's case in Anderson says. Look, when you got a conspirator who testifies that I conspired with these people to commit this kind of fraud in this kind of company, well, the credibility determinations go in the way of the jury's verdict. You got two witnesses, and one says he joined the conspiracy, and one says he didn't. Well, you got to go with the co-conspirator and the jury's verdict. The second reason is the sales scripts themselves, which the government contends are facially misleading in a number of ways. Any rational finder of fact could find that the facial misleading nature of these sales scripts is plenty of reason to send this case to a jury and therefore uphold the jury's verdict. A number of those misleading statements are outlined in the script, but I'll touch on a few of them. But the broad point here is that this defendant, Mr. Sand, was the one who was in charge of making sure that these sales scripts are used. Mr. Sand personally used those misleading sales scripts or oversaw their use every single day that this company was in operation for 6 years.
And did that come from Gerard? Did that argument or that piece of evidence come from Gerard's testimony that Mr. Sand was in charge of making sure these scripts were used?
It came from both her testimony and from Mr. Sand's own testimony. He will, if you look at the transcript, day 10 at 67 through 70, he talks about being the vice president of sales and what that involved. It involved listening to or monitoring sales calls all day long. And that's at transcript also day 10 at 87 and 89 through 91. John Sand's the man, and where this fraud is occurring is on his sales floor. The rest of this operation is just trying to hide what's happening on the sales floor, which is misleading all of these customers by telling them they're getting one thing and then selling them something else. So a few examples of those sales scripts and how Sand knew that they were misleading, not just facially, but in other communications that made him aware of that. One, Sand himself, and more generally all sales agents, were trained about what major medical or traditional health insurance really means. He was trained, and this is Government's Exhibit 6, that there are 3 musts to have major medical: a deductible, a copay, and a maximum out-of-pocket. The sales script, in specific contrast with the sales agent training, tells customers that there are 2 musts for a product to be a major medical. What do they leave out? The maximum out-of-pocket, because they do not want customers to know that the product they're selling has no maximum out-of-pocket risk. And I think one of the most damning things that occurred on Mr. Sand's cross is when he was asked, well, is that kind of a big deal that customers' costs are not going to be capped? He said, well, it's a difference. Is it a significant difference? Well, I'm not willing to say that, right? It's a consciousness of guilt. What was important to the consumer was that their costs were going to be capped or whether they're going to not be capped. Here, obfuscation all the way down, specifically defining major medical incorrectly to the customer on the sales call so that they won't know what's going on. Another example, limited indemnity, of course, is specifically defined by the fact that the insurance company is only making limited payments. So what did the sales script say? Well, it said there were no limits on the plan's usage, right? Diametrically the opposite of the product they're selling. It's a limited indemnity plan. The sales script says no limits on the plan's usage. The plan administrator, who Simple Health is selling on behalf of, would occasionally do what they call they're like undercover calls, right? Where they call in, they pretend to be a customer, and then they sent a report to Simple Health. And one report that went to John Sand specifically described this statement, no limits on the plan's usage, as misleading, went directly to Mr. Sand.
Mr. Reed, the page 5 of the district court's decision on motions after verdict is talking about why the district court concludes that Sand did not knowingly devise or participate in a scheme to defraud. You're laying out the evidence that the jury was presented with. Obviously, we have the jury verdict and the applicable standard. Is there a distinction on page 5 or page 6 in the judge's ruling that we're not picking up on, or that you want to specifically address in the way that he says Sand did not participate in the scheme you're describing?
Yes, Judge. Respectfully to the district judge, I think it's a misunderstanding of the Rule 29 standard. In the section that you're describing, he describes what he calls conflicting testimony. And because there's conflicting testimony, he grants the motion. But of course, conflicting testimony is classic jury territory, right? If there's conflicting testimony, boy, that's a case for the jury, not for the judge under Rule 29. I think there are a few other things in what the judge says. He also references what we refer to as off-script lies. So there were times where you would have sales agents who would take these statements in the sales scripts and kind of make the less subtle way of doing it, right? So the sales scripts say, oh, we're selling major health insurance, but an agent might say, we're selling Blue Cross. Or the sales scripts might say, you get up to 70% off, but the sales agent would say 70%, right? And so the judge in his orders said, well, it's not clear that there's anybody out there that was making these off-script kind of bald-faced lies that wasn't removed. But I think, in fact, there was testimony. It was the testimony of Katrina Ruth, who specifically described 3 people who got promoted after John Sand was told, if these people are going off-script, they're making the bald-faced lies. Those kind of people, in her experience, were promoted, not removed. And so I think that testimony, it's on the record, and really that distinction between up to 70% when we know 70% is a bald-faced lie, that's intent to defraud, right? If we're making a distinction between up to 70% is technically not falsifiable, but 70% absolutely blatant lie, and John Sand said this on cross-examination, well, that's intent to defraud, because you want your customer, you want to say one thing and you want your customer to hear something different. That's intent to deceive, that's intent to defraud, and I'll reserve the remainder of my time.
Very good. Thank you, Mr. Reed. Mr. Radefeld will now recognize you for argument on behalf of the appellee.
Thank you, Judge. May it please the court. Mr. Reed, my name is Matthew Radefeld, and I was appointed under the Criminal Justice Act to represent the appellee, John Sand, in the government's appeal of the trial court's granting Sand's motion for judgment of acquittal after the jury's verdict of guilty on all counts was returned. Now, as sometimes what happens when you're preparing for oral arguments, there are some things that may be brought up when you're reading the briefs and reading the law. And I will say that neither party addressed the fact that the trial court actually reserved ruling on Sand's motion for judgment of acquittal at the close of the government's case on day 9 of the day 12 trial. And I think this ultimately addresses the standard of review in this matter. According to Rule 29, subsection B, it states that if the court reserves reserves decision on the judgment of acquittal, it must decide the motion on the basis of the evidence at the time that the ruling was reserved.
Now, this part of the rule seems to create kind of a stop point in the trial, wherein the trial court's determination of whether the evidence viewed in the light most favorable to the government exists was sufficient enough for a reasonable juror to find Sand guilty beyond a reasonable doubt was simply not satisfied here, which is the ultimate baseline here. Because during the post-verdict hearing on Sand's motion for judgment of acquittal, the trial court stated that it did not believe that the government made the case originally against Sand, but wanted to make sure that there would not be another trial, so it allowed the matter to be submitted to the jury. But the trial court was clear that it believed that the government did not prove its case against Sand beyond a reasonable doubt in its case in chief. Then the trial court supplements its in-court statements with a written order spelling out its finding of facts. And within this order, the court acknowledged the high burden of granting a judgment of acquittal. But in this instance, from sitting in a 9-day trial, if subsection B of Rule 29 is followed, or even if after the remaining 3 days of trial are considered, the trial court did not believe that the government viewed the evidence that the evidence viewed in a light most favorable to the government would have led a reasonable juror to find Sand guilty beyond a reasonable doubt.
Mr. Radefeld, how do you get around the cooperator's testimony? How do you get around what Ms. Gerard got on the stand and said that she had conspired with Sand and others to engage in these deceptive sales practices, and consumers on the phone would be deceived with the scripts that were read by Sand and overseen by Sand, and that he had even 2 scripts in one situation where the healthcare company said you have to use this one because it's accurate, and he would only use that one when he knew the healthcare company was monitoring it. The standard is so high on a Rule 29. Could a rational trier of fact have found him guilty beyond a reasonable doubt if we just accept all of the cooperator's testimony?
Yes.
Why couldn't a rational trier of fact have found Mr. Sand guilty beyond a reasonable doubt based just on that testimony?
Yes, Judge. I believe the trial court addressed this exact, I think, issue in the written order, where most of the evidence that was heard, if was, and especially from Ms. Gerard, that there was a lot of speculation. There was a lot of pure...
I just read directly from what she said, that she, Sand, and Dorfman agreed to commit fraud through deceptive sales practices with consumers on the phone, and that the scripts were misleading and deceptive. Maybe it wasn't the strongest case ever, but that's not what the standard is for Rule 29.
Correct, Judge, but what the totality of the individual's evidence, I mean, I believe what the court was just referring to was upon the answer upon direct examination from the prosecutor, okay? At the tail end of examining the co-conspirator, you know. So it's a conspiracy, yes. You did this, yeah. But from all the time beforehand, before all of that, there was well, he should have known. Well, he could have known, or he would have known that. And all of these speculations that were even brought up by Ms. Gerard were not saved by the ostrich instruction given to the jury, wherein the government did not present any evidence that Sand took steps to avoid knowing that something illegal was going on. So Ms. Gerard, what the court did say, you know, that Mr. Sand was selling a product that was legal, that was told to him or following a script that was approved by the third-party administrator. And that you heard from the government's own witnesses that these policies that they were selling, that these policies sell themselves. So this isn't kind of like a methamphetamine case where the product here was legal and is sold and purchased by hundreds of thousands of people in the United States. So it kind of left like the sole issue in the case to be the way that Simple Health sold the policies. And it was told through the government's own witnesses as well that these scripts were being used industry-wide, and that John Sand was told to have his sales agents use these industry-wide scripts by the third-party administrator. And Sand was told that the TPA, the third-party administrator, approved the scripts, and there was no evidence that proved that Sand should have known that these industry-wide approved scripts were false or misleading. And the government's focus on these two scripts being used, but there was no evidence other than that the two scripts were sometimes being used at a point where it was like testing out a new product in a market. And was Sand told to switch the scripts out at a certain time? Yes, at the directions of others. But there was no evidence that Sand was purposely doing things behind the compliance department's back when the script would be changed improperly or falsely. That the evidence that was presented that never showed that Sand was part of any expressed or implied agreement to actually be part of this conspiracy, or to allow or encourage his sales agents to go off script and make these false statements. When John Sand was on that sales floor using this script and being told that it was okay to use that script, there was nothing misleading or that he would have known or should have known that they were misleading or false. In fact, the government presented certain witnesses in this case. And this actually goes to counts 2 through 13 here, where the federal or the prosecutor relies heavily on United States versus White. And in that particular case, the co-defendant, Ford, was personally involved with all the scheming and the preparation of each fraudulent mortgage paperwork. And then the wire occurred after that. And that's not even close to what we have here. In counts 2 through 13, the government never presented a single piece of evidence that Sand was actually the supervisor on duty when those sales agents sold those policies, or that John Sand was even in the same call center, since they had call centers in different states and in different locations. The government never presented any evidence that Sand was even working that day. However, these witnesses that were brought in, and they talked about some of them received a much more significant benefit than they would have paid in a major medical plan. And that there were literally pennies on the dollars saved for some of these people. That's not false, that's fact. And the majority of these government witnesses kept these plans for a significant period of time. One kept his plan for 4 years, paid significantly less money than he ever would have spent on a major medical plan, but now he cries foul. And the government's own expert witness, who was a retired government agent, said that a person could purchase one of these plans, be absolutely satisfied with it, keep it for years, and yet the government would still consider them to be a victim. That does not make any sense, and the trial court saw through this and concluded that the jury's verdict in this case was based on speculation and guilt by mere association. And the trial court did not, as the government accuses it of doing, substitute its own views for those of the jury. It didn't fail to weigh the evidence in the light most favorable to the prosecution, and it did not fail to consider the jury's apparent credibility findings. Simply put, the trial court reserved rulings on Sand's motion for judgment of acquittal at the end of the government's case, and it was hopeful that the jury would get it right, but they didn't. The trial court knew the breadth of the legal standard to say that defendant Sand was improperly found guilty by the jury, and the court soundly ordered that the evidence submitted at trial by the government as a whole was insufficient for a rational jury to find guilt beyond a reasonable doubt on the charges against John Sand, as he cannot be convicted on allegations based upon speculation and mere association, and that is all the government presented to the jury, and the trial court knew this and ruled accordingly. For these reasons, and on behalf of the appellee, John Sand, we ask that you affirm the order of the district court and allow judgment of acquittal on all counts. Thank you.
Thank you very much, Mr. Radefeld. Mr. Reed, I'll recognize you now for a rebuttal argument.
Simple Health got cease and desist letter after cease and desist letter from companies that benefited from Simple Health making sales. Unified Health sent them a cease and desist letter. Stop selling our products. Why? Because they were being deceitful. And who was being deceitful? John Sand's sales agents. And another cease and desist letter from HII, the plan administrator. HII back in 2015 sent a cease and desist letter to Simple Health that said, stop saying up to 20%, or it's up to 70%. Stop telling customers they're going to get that because they're hearing 70%. Cam Gerard testified, she sent this out time and time again. Got to get this language out. We got to get this language back out. She testified that Mr. Sand and Mr. Dorfman conspired behind her back, behind compliance, to repeatedly put it back in. 3 years later, in 2018, the use of that language was the chief complaint from customers. I thought I was going to get 70%. Thought I was going to get 70%. And Sand was not just a passive manager of an entire sales floor. He specifically was involved in this precise project. Not only Gerard's testimony, but if you look at government's exhibit 146, there are handwritten notes by Mr. Sand putting this language back in the script, adding deceptive language to the sales script. And if you look at his cross-examination, he denies initially that he wrote those. Why? Because he knows.
Was 146 admitted during the government's case in chief?
Yes, Judge, 145.
Not during the cross-examination?
Correct, Judge.
Okay.
Yes. He looked at those notes and he said, I don't want to have to take credit for those. He denied it, had to be shown a handwritten sample, at which point he conceded, yes, I was the one making notes about changes to the deceptive sales script. For all these reasons, we'd urge you to reverse the judge's order and affirm the jury's verdict.
Thank you, Mr. Reed. Mr. Radefeld, you were appointed by the court. You have the great thanks, you and your firm, for your strong advocacy in the case. The same thanks to Mr. Reed. The case will be taken under advisement.
Yes, sir. Thank you.
That will close our hearings for the day.